Ladies and gentlemen, dear colleagues, a cordial welcome.
2016.
Ja, sehr geehrte Damen.
Ladies and gentlemen, welcome also from my side. So before we start with the agenda and hear the opening speech of Professor Mellinghoff, we wanted to introduce ourselves. We too are going to moderate, like in 2014, and going through this event. The lady on my right-hand side is Mrs. Dr. Ephah Oertel. She's the speaker in the Bavarian Ministry of Finance, and she's responsible for tax policy and international tax law. But above all, she's also responsible for the International Office of Taxes, which is associated with the ministry, which is a unique project of the Bavarian Tax and Finance Administration that is seeking to support the cooperation of the financial authorities, and international tax audits and joint tax audits and external audits can be carried out. And this young man to my left, he's a highly esteemed former colleague, and he's also speaker and officer of the Bavarian Financial Ministry. But then he was going to WTS consultancy. He was just as successful, and he became the partner and the head of the National Tax Office, and that is the principal officer at the PTS tax consultancy, but he's also the board member of the support association that also supported and financed this event. And that's why you see a board member from ITAX Ephah. Now it's a special honor to welcome Professor Mellinghoff, who is going to do the opening speech of this event. He was a judge at the Federal Supreme Court of Finance, and then he was also a judge at the Federal Supreme Court. And then in 2011, he returned back as president of the Federal Supreme Court. And he's a co-editor of the big comment about the income tax law, the Kirchhoff-Söhn-Mellinghoff. And he's also founding member of the association that is also organizing this event. Now let's welcome Professor Mellinghoff here on stage. Ladies and gentlemen, and I'm so happy to be here with the second event and to talk to you. And we're moving in the field of international tax law, and we're working on international companies and globally active units, more and more acting on unsecured terrain, and they're being blamed by aggressive tax planning that the tax income of the member states would be weakened, they said. And even in 2008, the European Commission announced that Europe will be weakened by tax evasion and is losing more than 1 trillion of taxes. You have to mention that 1,000 billion euros. That's the amount they say that's being evaded. So we're looking great times. All the plans are being implemented with the publication of company and tax data. Then the global tax evasion will be fought against, and international research networks will help, which are operated by press and the radio stations, with offshore leaks and Luxembourg leaks and Panama Papers, caused a wave of astonishment and this outrage. And so that's the latest is the publication of a green politician. And you also have to look at the wording of the politician and see whether that is an appropriate dealing if they say that BASF is using a bad system in order to avoid taxes. And I don't believe this is not a wording that is rather helpless in talking about a perfidious system. And that is really helpful. So that also implies the obligation that income of a certain country and profits will go to a high-tax country without the tax principles fully being taken care of. So with all the moral outrage, there's one thing or two things that are quite interesting. So the companies are not being blamed of having evaded taxes or having made wrong statements, but the only thing they are being blamed with is that they used applicable tax law, and also that they blamed the companies, although many states targetedly capital investments of large companies have used them, and also because they're soliciting with tax incentives. So the effects of such dealing to the taxation, so the European Union demands further tax payments from Ireland of 13 billion euro, but also from companies in Belgium and Luxembourg. Further tax payments are being expected, and also in Belgium the tax authorities will be checked as well. And also on the European level, on the international level, there will be outstanding measures that have been taken in order to accomplish a fair taxation, measures that also were possible in earlier periods, that would have been possible earlier. In addition to that, these measures will help the OECD with the BEP project, and they will also being implemented on a standardized basis, because ultimately the European Commission is assuming a new attempt for an in-depth reform of corporate tax reforms, where a joint consolidation in corporate tax assessment basis will be created, but also the Commission will also have an influence on the expenditure behavior, so that the EU Economic Commissioner, which we see, said that he or the Commission will be seen as a collective financial, and that they will act as collective financial ministers.
In view of such wide-ranging changes, the legal expert is surprised, and one tries to find some kind of anchoring in the European law. In the public debate at the moment on the proposals, one can see that the structures in the international tax law will be changed or should be changed completely, and then constitutional issues will be put in question. According to the ideas of the European Commission, the common corporate taxation basis is going, or is meant to be, a uniform set of rules and laws for the EU as a whole, and in comparison to the proposal from 2011, the new system is going to be obligatory for big international companies. The joint consolidated corporation tax basis, calculation basis, are expected to apply for companies which have more revenues than 750 million euros, according to the press release, in the land or country where they generate these profits. But this is not only going to affect the individual companies who have revenues of 700 million euros, but it will also include all the conglomerations of companies as well. The biggest capacities will be affected, and the uniform corporation tax base assessment are intended to close tax loopholes intended to transfer profits to other countries. This calculation basis is meant to be a more transparent and effective system for calculating the tax base, and in doing so create a fundamental reform of the taxation in the EU. Thanks to the KKKB, the corp tax compliance deadline is going to drop by 8%, and the taxation for affiliates will go down to 67%. The assessment basis will stop discrepancies between national systems, which at the moment are used by aggressive tax planners, and furthermore, transfer prices and tax reductions or tax benefits will be closed or stopped, and the tax incentives will be taken away from big companies, and there will only be a decision about the corporation tax rates, which will be in the hands of the individual countries. All the other thing will be subject to European law. Whether such a corporation tax assessment base law will be introduced or not is a decision that will be taken on a European level, and it seems enticing if global companies only have a uniform tax system in the European Union, and in the member states or the member states will only decide about the height of the tax rate. Cross-border audits would then no longer have a problem with different tax legislation in the various member states. And the tax audit forum would be able to have different focal points. And at the same time, such a concept also brings up a lot of questions. The European Commission wants to limit these regulations to companies whose worldwide annual revenues exceed 750 million euros. But is that actually possible? And it seems quite questionable whether such a limitation is practicable and actually can be carried out. In every individual case, one would have to examine whether an individual company is part of such a group of companies, and this group of companies would have to be defined by European law as such. And if you add the liabilities of the previous year, this would mean that the obligatory uniform assessment basis might be applicable in one year, but not applicable in the next year. So de facto, it's inconceivable that this type of determining the profits would only apply to these types of conglomerations of companies, but it would also apply to other corporations, or have to apply to other corporations. If you look at the general principle of equality, because can you only treat companies differently that are the same size because one belong to an international conglomeration and the others don't? And if you also take into consideration that we in Germany have a structure of companies which are defined by private companies, then this would also mean that such a uniform corporation tax assessment base would apply for the entire assessment of profits under taxation law. But if one doesn't only look at the value-added tax, but if the determination of profits is subject to European law, that would mean that a great part of the taxation law would fall under the competence of the European Union, and that way the core competences of taxation, which as far as VAT is concerned already is on a European level, and that would then also apply to income tax. And this means that would raise other competence questions, which then will have to be clarified once the previous issues have been laid down. In the 18th century, one already said no taxation without representation, and that means if taxation law is so comprehensively transferred to European law, one would also have issues relating to democracy. But if you also think about the introduction of such a tax assessment law and you consider that to be problematic under various other legal issues, then one would have to say that only the unanimous introduction of such a European regulation would be possible. But that would also mean that every individual amendment of such an assessment basis on would have to be passed unanimously on a European level, and that inevitably would lead to a fossilization of the taxation of global companies, because if even one member state could prevent such an adjustment. Who knows? Those who know the law of profit assessment knows that a flexible adjustment to economic changes is very necessary. We all know how often the assessment basis for defining profits has been adjusted or is adjusted, and that is why a uniform tax assessment basis on a European level would also entail a change in an amendment of the law defining direct taxation, because only that way the necessary flexibility would be achieved. A uniform assessment basis basically only makes sense if, for the interpretation and application of such an assessment basis by the administration and the courts, the European level would be competent. The financial administration of all member states would then have to agree on a European level about the uniform interpretation and application of such an assessment basis. Because otherwise the desired simplification effect would not be achieved. And we know how pleasant it is to discuss about the whole term of entities and establishments. And in Germany, that's already difficult, and on a European level, that would be even more difficult. And uniform corporation tax assessment base would presuppose that legal protection is defined by European law, and it's not sufficient that one organizes the litigation of disputes. Rather, the companies and those involved in economic activities in Europe would have to, and those who have to apply this assessment base would have to get effective tax legal protection, and which guarantees that the regulations would be interpreted uniformly throughout the whole of Europe. Whether the present system of national legal protection with presentation to the European Court is sufficient is questionable. Already today, the duration of administration and court procedures mean that many tax issues no longer reach a court, and if one has a lengthy presentation procedure to the Federal Fiscal Court of the European takes very long, then one has to ask oneself whether that is legally consistent and actually compliant with legal protection. So there are a lot of issues which might be facing us in the future. So let's just wait and see whether such a uniform tax assessment base will actually ever happen. But we will not have a problem if we look at applicable law, and that is why we've come together today. And I would like to mention the big uncertainties which exist at the moment, not only because those who are liable to taxes and pursue cross-border activities are subject to different legal systems and tax systems, but also the influence of the European law creates further uncertainty. One example for this are possible violations against the European law of legal assistance, and this basically the taxpayers bear the brunt of that. There is discussion whether the new inheritance tax and the limitation of special write-offs according to Section 4 or 7, if certain limits aren't exceeded, or whether the support of research activities are inadmissible aids. The state doesn't have a risk, because if you have a violation against European law, the taxpayer does not get a protection, but has to repay tax reliefs. And even if one has a statement by the tax authorities and confirmation that certain things are allowed, the taxpayers have to pay back if the voices in literature are right, that the protection of companies, for example, in the compromise which was achieved in terms of inheritance, then they would have to repay any inheritance tax that might have to is adjudicated differently. So the European law of aiding and abetting is correct, but the individual taxpayer and the companies here have to get legal protection at the moment. This is the simplest. If all dubious regulations are notified with the European Commission in order to get at least a minimum amount of protection. Let me just mention one last point which went through the press very recently, and that is the so-called country-by-country reporting. You all know that the EU administrative aid directive was supplemented, and an exchange between the tax authorities under the protection of tax secrecy or certain similar regulations in the member states, and that exists. And at the moment, this is implemented in Germany as well. The European doesn't only want to have an exchange of information between the tax authorities concerned, which basically is subject to the law of secrecy. The EU Commission demands a public country-by-country reporting, which is not subject to the secrecy within the framework of accounting and reporting. And we all know that this is very controversial in the federal government. Only at first, your complete transparency of corporate data is advantageous for wide-ranging publication as a part of the reporting should probably give rise to competence issues and data protection issues, and furthermore, it would have negative effects for the economy. So the question arises whether we are talking about a regulation in the field of capital market law or tax law. In the former case, there is, or a qualified majority would be sufficient, but if you have a regulation under tax law, you would have to have a unanimous decision. And let me point out something that was published in the Handelsblatt last week. Here, the legal service of the European Council of the EU Commission said that the wrong legal basis was chosen, and that Section 15 provides that these publication could be passed with a qualified majority. Germany could be overruled, and the legal service, on the other hand, demands unanimity. And you all know that the finance minister Schäuble is against a public country-by-country procedure. If we're talking about a tax regulation, and not the Ministry for Economic Affairs is not competent, but the Ministry for Finances is competent, and then Germany would be able to act. For reporting by the countries, there are other reasons, i.e. a limitation under the secrecy provisions that is necessary if the tax authorities have an exchange, but that doesn't have to be published because the transparency doesn't serve the information of the tax authorities because they have this data anyway. But this is this data is for exerting public and moral pressure on the companies to pit two countries against each other and forcing companies to make concessions. So what is not applicable is applicable law, but the published public opinion about the appropriateness of tax payment in one country.
There are many questions for the taxation of the companies, in which relation the desired public pressure on companies it stands, and with regard to their tax strategy and tax payment related to the work of the financial authorities, the verification authorities in tax matters. And what are the effects of the transparency proposed on the individual countries on German companies, and where should this transparency change? I would like to give you just one example, which are the actual problems that come from a publication of the company data. Enhanced transparency is supposed to make sure that the place of taxation is the same like the place of the economic activity. But what means the adequate taxation at the place of the economic activity? Would they like to provide taxation where the employees are working, or where the income is being generated or revenues are being made? This does not goes in line with the new state's regulations for the determination of the transfer prices in the group, and not the right of the individual with regard to direct taxes and to work autonomously against the EU member states. But it also corresponds to the ideas of BRIC states, Brazil, India, and China, and individual NGOs. Such a concept, characterized of changes of international taxation, would have adverse effects on the German economy and thereby also on the German tax income. That means more taxes would have to be paid abroad, and there would be a lot of double taxation cases. I made this a few statements and examples to show you the difficult environment we're currently working in, and how necessary and how important it is going to be that we should go back to applicable law, and that we should rely on applicable constitution law and applicable European law, and use these directives and regulations, and the national and international law will be sensitively adapted to these international challenges, and in order to avoid that big drafts would be put into the world that would lead to major problems later on. Thank you very much, Professor Mellinghoff, for this very interesting presentation, where you also have impressively underscored the claim of this meeting, because we want to share practical experience, but we also want to provide scientific insight, and we can also discuss tax policy today, and that's why this starting presentation was the perfect starting point at this point. And so practical experience will be the focus of this meeting, like in the last forum. And we always, like the previous year as tax officers, like in the last forum, we also want to have two scientific presentations. And for that, this time we had extraordinary, reputable scientists to speak here. The forum is becoming much more international than in 2014. Now we will have our first speaker, Professor Michael Lang, who is internationally known and reputable. He studied law and administration, business administration, and he holds a lecture in the University of Vienna, and he's the board of management of the Austrian International Tax Law, and he's also scientific head of the LLM study of international studies, and since 2014 he's the deputy president of the university. But also should I mention his law of numerous international guest lectureships, and also his international scientific activities. Professor Lang will take care of the legal protection of taxpayers in order to avoid double taxation. And therefore, he also starts with the real case discussion that is dealing with the international external audit, But it's also the basis for the high-level discussion we're going to have tomorrow. That is also talking about the legal protection of taxpayers. You also know the title, Any Rights Left? And we're going to deal with that tomorrow in more detail. Now, we're going to have an exciting analysis of the status quo and further information. And now we would like to welcome Professor Lang. Ladies and gentlemen, dear colleagues, and I also would like to welcome you cordially, and I'm happy to be here and at this meeting to speak here for this event. And so I'm happy to talk about questions of legal protection and legal protection in the case of double taxation. A few years ago, we would have thought that legal protection in double taxation is part of is quite important. So it's important to have we want to avoid double taxation. So with all the PEPs discussion, we had rather the impression that this is a marginal topic. That is the avoidance of double taxation and where for tax and legal protection, whereas other topics are important in order to avoid the double non-taxation, in order to close taxation gaps. And that's why I'm happy that the organizers also focused on legal protection in double taxation. All right. So in my presentation, in this half hour that I'm having here with you, I want to refer to questions of national legal protection and international legal protection within the meaning of the double taxation treaties. And also would like to talk about the European law. These are the main topics, the three main topics that I'm going to take care of. I'd like to start with a few structural questions, and you might ask, there's double taxation treaties. There's a network of 3,000 double taxation treaties worldwide. So why is there still such a thing like a double taxation? So this network is quite comprehensive, but it does not include everything. And then, of course, we need to know that despite the double taxation cannot always be avoided because the personal or factual application of the double taxation treaty, it does not help here in this case. Beyond that, there are a few more structural topics that you would have to look at. First of all, the double taxation treaty. These are treaties by international states, and also, it's important by international law, and that's why they can be interpreted by different states. And that's why it's quite natural to see that they have been that they might be interpreted in a different manner. But also, there are a few more national problems or internal problems that could be avoided, and which are not coming from the structure, but for example, the interpretation regulations, Article 3, Section 2 of the OECD sample agreement that you find in all worldwide double taxation treaties. And they're trying to close the gap between the double taxation treaties and the national law for interpretation purposes. However, this is done in a rather unclear manner. And libraries are full of the questions of with regard to the wording if the context does not require anything else. And that's the reservation for national law and in terms of what that means. And that's a regulation that has caused more damage rather than it has rendered benefits during the past few years. And it's quite regretful that when you look at multilateral instruments, that there's also Article 3, Section 2 of the OECD sample agreement also have that there will also be similar interpretation rules that should be incorporated. But it will not solve the problems we're having. It's going to increase the problems. And also further attempts and efforts of the financial authorities and OECD. Basically, the intention was good, but the result does not look that good because these are the changes in the OECD comments over years. They were trying to clarify the situation and in the OECD comment, but they missed. They did not see that the OECD and the government representatives sitting in the tax committee do not see the legal principles, and that's why the Federal Court of Finance consistently acted that not every wording in the OECD comment should be seen as an authentic interpretation. Moreover, courts also use the versions of the OECD comment for the interpretation of the double taxation that have been presented as a when the double taxation treaty was entered into, which means that we have less consistency in this law, despite we having uniform wordings, and so depending on whether when the version of the OECD comment has been published and when the regulation has been passed. And also the different interpretation attempts of the partnership report, which includes some innovative approaches. And they have been designed in the year 1999 in the concept phase, but they have such a high level of innovation degree, to put it carefully, so that not all courts in the world were able to follow these approaches in order to solve qualification conflicts. These are a few internal problems that I wanted to mention at the beginning in order to see the framework. Talking about legal protection in order to avoid double taxation, then primarily we have to talk about national law, because despite of all the instruments we have in the double taxation treaties, legal protection has been worded nationally, and they're part of national law, and that's why we have to rely on the fact that the legal protection mechanism of national law will work properly. And I said already that we have different mechanisms that we're using in the different contract status, and there's no such guarantee that two courts in different states come to the same result. And of course, there should be the effort that states and courts also use the interpretation done in other countries and deal with that, and that's desirable, and that is happening more often in the past as it used to happen in the past, because there's much more information available, and a lot of institutions have also strongly got involved in order to make these judgments transparent. But naturally, I mean, that is so. It cannot have a binding effect with regard to decisions into another country, and that's a principle of the legal principles. And of course, there are some limits set to the decision-taking power. In addition, a lot of national courts strongly tend to use double taxation treaties in a manner so that they can be interpreted for the benefit of their own fiscal system. The Federal Court of Finance, I'm not saying this because the president is here, because they make a good exception here where this tendency cannot be visible at all. But in many cases, the state or the national interests play a major role in interpreting the double taxation regulations. And there's a certain bias among courts, and you might say this is like an unwritten principle, in dubio pro patria. That is applicable in some states who always go for the benefit of their own national system. There are also areas where national legal protection practically fails, like in transfer prices, where simply administration topics are linked with questions of interpretation and the question of the subject matter, and they're closely linked, where the courts do not have the expertise and people do not recognize the court's expertise, and so that's why companies not always have the trust in order to make it pending before court. There's also a legal protection gap in many cases and in many countries, and there's also in Germany that is the case. There are hardly any cases of transfer prices which will be pending before law. Although these questions practically play an important role, but I think it's also required that the legal science gets more strongly involved with the questions of transfer prices, and that they should deal with it more scientifically and legally, and they should not left it over to business administration, although the intensive cooperation would be needed.
And this brings me to the legal protection mechanisms that have been defined by internal law, the agreement or mutual agreement procedures. And here one has to say that the mutual agreement procedures only help to a certain extent in order to prevent double taxation for various reasons. On the one hand, the closed mutual agreement procedure isn't the end of the procedure, and it can't be, because mutual agreement procedures, even if they avoid double taxation, are basically agreements which are made by the administrative authorities and have to be subject to legal court control. So that is why I think that the trends in legislation in Germany as well, that they attempt that mutual agreements are immunized, and there's an attempt to take them away from court control, which is understandable to a certain extent, but on the other hand, in a country of law and order, problematic, because we have a separation of checks and balances, and my view is that the Federal Fiscal Court is very reserved in terms of these legal attempts and interprets certain decisions very restrictively. And in addition to that, the mutual agreement procedures as such are insufficient. There is no legal claim for the initiation of a mutual agreement procedure. And above all, there are no rights for the parties. This is a procedure between the administrative authorities and not a procedure where the taxpayer necessarily plays a role. And this is a procedure, and this is probably the biggest deficit, where there is one doesn't have to reach an agreement, and there are always cases where you have mutual agreement procedures where the administrative authorities try very hard, but after many years come to the result that they haven't reached an agreement. And for some years now, Mr. De Eins has asserted himself that mutual agreement procedures have to be improved, and there were efforts that arbitration procedures be a complement to the mutual agreement procedures. We've got lots of bilateral double taxation agreements and German double taxation agreements which provide for these types of possibilities, and the OECD model agreement knows these types of regulations, and it's very good that it's part of the base erosion and profit shifting. There are attempts that arbitration procedures become more anchored within the framework of the international network of international agreements, and that the arbitration procedure becomes gets a more prominent role. And we will see that to what extent the arbitration procedure becomes more a part of multilateral procedures. The regulations which the OECD is envisaging are very flexible. This is a procedure that, to a certain extent, is determined by the administrative authorities or the competent authorities. One would have to have one independent expert. They agree on a chairman according to the ideas of the OECD. If one doesn't reach an agreement, or if one or both parties are in default, the OECD Center for Tax Policy and Administration would have a subsidiary role, so that you don't have a legal gap or loophole in the procedures for the initiation of the arbitration procedure. And the OECD, therefore, was successful in setting a milestone and placing itself prominently in the international world of international law and international taxation law. The idea of the OECD is very much defined by baseball arbitration, which is in the foreground here, and the rules and regulations and the procedure allows for other alternatives as well. When you have baseball arbitration, we are talking about a procedure that is carried out very quickly or relatively quickly because both parties provide a best offer, and then the arbitration court has the choice to decide for one or the other proposal and can't choose for a third proposal, which is an incentive for both parties or both authorities filing proposals which they believe would be the most likely to be accepted. And which means that they would already be moving towards the center. That is the advantage of the baseball arbitration, because it means that one can arrive at a result relatively quickly. But there are disadvantages as well, and I think big advantages as well, because this is a procedure where we don't get a reason for the decision, we just get a result, a figure basically, but we don't really know what the motives were behind the decision of the board to arrive at one decision and not at another decision. And for the further development of the law, we can't expect a lot from baseball arbitration, because arbitration courts and other authorities would not be able to draw any conclusions from the decisions taken on the basis of a baseball arbitration. And that's something we will miss with this baseball arbitration. So we hope that despite the reference to baseball arbitration in practical everyday ruling, one would find alternatives. The OECD gives us some leeway here, or gives some leeway to the authorities to take other routes and use other procedures. I first of all praised the efforts of the OECD within to anchor the multilateral instrument more in this framework. But let me also qualify that what I find very regrettable, and here the big expectations of science and practical experience show that the regulations of the arbitration procedure are a minimum standard for the implementation of the entire project. The regulations of legal protection, mutual agreement procedures, arbitration procedures are the only part of this program which is focused on to the benefit of the taxpayer. All the other elements are focused on the fiscal administration, and I think here one could have focused more on legal protection in order to avoid an imbalance. These standards are only the regulations of the mutual agreement procedure as we have it at the moment, with certain nuances of change. For example, that a mutual agreement procedure can be initiated in the source state and in the state of execution. So one can ask oneself whether this is really useful, because if the regulations of the mutual agreement procedure is considered to be the minimum standard, i.e. regulations which are 99.9% are already included in the double taxation agreement. So basically this is instrument of the OECD where some people were very ambitious and where the arbitration procedures wanted to have a minimum standard and realized that they couldn't get a consensus, so they withdrew by saying that what one has anyway today already is insufficient, but this would be the mutual agreement procedure, which is then declared as a standard. And one could ask oneself whether what we think that this isn't a step backwards, because if we look at what is happening with the multilateral instrument, and a arbitration procedure was a part of the OECD model agreement, and one would assume that this would have been the minimum standard internationally. Now we're taking out certain regulations out and call them a minimum standard, and here the regulation for arbitration procedures is not part of that. So I think this leads to a certain dilution of the model agreement, and I ask myself whether the current developments will mean that the arbitration procedure is triumphant. I tend to doubt that. And the last part of my presentation that I would like to deal with is the European protection. What possibilities exist in the European Court of Justice? We've got this court of law, and the adjudication says that double taxation as such does not violate the law of the European Union. This was criticized a lot. I don't agree with that. I think that one has to remember that the legal basis that we're talking about here are the basic liberties, and basic liberties are based on non-discrimination, and these are not general regulations against the avoidance of double taxation. So from my point of view, I think it's understandable that the European Court of Justice doesn't have a general principle relating that double taxation violates the law of the Union. And because I think that the law of the European Union is not a proper base. One would expect that the European Court of Justice would deal with the non-double taxation in the same way as other areas. Here I think there's an imbalance in the adjudication of the European Court of Justice, because it's not so consequent, and the prohibition of the non-double taxation isn't laid down as desirable as that would be. I think there is no solid basis under union law. The basis here is basically a prohibition of discrimination, and therefore only in very certain situations they can provide protection against double taxation. Under union law, for some time, we already have the arbitration convention as a multilateral international contract under international law. At the time, it was just a panacea. It turned into a contract on agreement under international law. And there's no control by the European Court of Justice. This multilateral agreement under international law is very limited in terms of its application. It only applies to transfer pricing, not to double taxation as a whole. And there are only very few cases. However, there is a thesis, which I agree with, that regulations, arbitration procedure regulations are not successful if there are lots of cases, but they are successful when there are very few cases. The preventive effect of these regulations shouldn't be underestimated, and that is why I think it is a success story in the relationship between Germany and Austria, for example. They've got a very special double taxation regulation since the year 2000, i.e. the competence of the European Court of Justice for interpretation conflicts in double taxation. And this is the first case, and there will be a hearing on the 6th of December before the European Court of Justice. Up until now, there have been no cases, which I think doesn't mean that this regulation wasn't successful, but on the contrary. And if you look behind the scenes or talk behind the scenes with the administrative authorities. One knows that where the communication is concerned, one points out to the other party, perhaps that this might be a case with which one could present to the European Court of Justice. And by saying that, one can sometimes achieve a solution with the other party, and one then tries harder to find a solution, and this is the whole point. And here, for some time now, we've got a draft of a directive, which the double taxation dispute resolution, a further development of the arbitration procedure. And it'll be interesting to see to what extent this draft will be taken up. Here, the Commission is trying to backpedal a little bit and correct the mistake of, or avoid the mistakes of 1990 and move towards a directive and place this directive on a wider base of application. This will apply to double taxation as a whole and go beyond the application area of double taxation. So it could be a legal basis ultimately for an advisory commission and ultimately for the European Court of Justice if it is called upon to have a subsequent examination, and that's what define who would get or should get a protection. I think this would be very interesting if it actually comes through. And also the directive draft has some interesting additional proposals. If individual countries, for example, don't nominate any experts, then there would be a subsidiary cooperation or participation of the laws. A court would then have to be appointed, and that would have a subsidiary role if one or two of the parties are in default. So the participation of the courts and their participation rights of the countries involved, there is a constrictive time frame during which these procedures have to be concluded. This is very important as well. And here one also has the possibility for alternative dispute resolutions. This is an open experiment at the moment, but in the foreground we have a founded or substantiated decision by an arbitration instance, and that is this is different to the development of the OECD. So because basically we would have a publication, and that would only be avoided if there is some confidential information that shouldn't be published. So if this idea asserts itself, this could be an interesting mechanism within the EU. And that brings me to the end of my speech, and let me summarize. I think that it would be wrong that protection under double taxation be neglected a little bit. It's not a scientific topic where one tries to fill the last gaps in legal protection. I think we will see that within the framework of the implementation, far more cases will be contentious between the various authorities, because the fiscal interest in the pie will be even bigger. The regulations will be more complicated, and a lot more issues will become contentious. So we really need effective legal protection mechanisms in order so that the mutual agreement procedure, even if it is the minimum standard of legal protection or I consider to be insufficient. So the initiatives that exist on OECD and EU level, I think, are need to be welcomed, and I hope that the OECD and the EU won't tire to provide to continue these efforts, and that due to the higher number of procedures that will arise inevitably, they might agree that one has to make an adjustment where legal protection is concerned on an international level. And that is a very optimistic note on which I end.
Vielen Dank, Herr Professor Lang.
Thank you, Professor Lang, for this very good analysis of the legal protection instruments. And you showed us the limits, and we saw that international legal protection isn't a solution. So I remember Professor Mellinghoff's speech in 2014 where he said that we should have international courts in order to clarify and decide on such international tax issues. But let me just underline one point. I also see that the focus is far too much on the avoidance of non-double taxation rather than double taxation. And in the next speech, we will talk about the rights of the taxpayer from a different perspective. The protection of the taxpayer where the exchange of information is concerned.
So we're happy to welcome one colleague from the British Empire. Mr. Phillip Baker is going to hold the second presentation. Phillip Baker is barrister. That means he appears regularly before British courts, and he's a Queen's Counsel. That's a specific award that is given to highly renowned legal counsels. And so if there will be a king in the future, it will be called a King's Counsel. But he's called Queen's Counsel. Also in 1997, he received the Order of the British Empire. So we're going to have a high-class personality that we're going to see on stage. Phillip Baker is highly esteemed and reputed because of his specific fine and nice British humor. For presentation, I looked in his homepage and his law office and in his CV. There's a nice statement about his private life that I found there, and I would like to share it with you.
His children are now too old for bedtime stories, but his ambition is to get home each night in time to prise them away from various screens and get them to bed. Beruflich ist Phillip Baker spezialisiert auf alle Fragen.
So he is focused on all questions of international tax law. He represents the private people, companies, but also he's also taking care of national and international matters before court. Currently, he gave an impressive presentation in the last Ephah Congress in Madrid, and currently he's involved in the Apple case, which is quite spectacular, and he was representing the Irish government towards the European Commission.
Honor to welcome Mr. Phillip Baker.
Good morning, everybody, and thank you very much indeed for inviting me here to talk to you today. Thank you particularly to the organizers of the International Audit Conference for inviting me. I hope that you'll continue to invite speakers from my country even after Brexit. I've been asked to speak today to follow Michael, which is a very difficult thing to do, but I've been asked to speak about another topic related to the protection of taxpayers' rights, and that's the protection of taxpayers' rights in the exchange of information. And I hope you'll forgive me for speaking in English. I stopped studying in German when I was about 14 years old, and if I tried to speak in German, it would be too embarrassing. Just to show you the outline of what I'm going to do, I'm going to run through exchange of information, a little bit about the background, which I think is very well known, and they say something about the areas of protection for taxpayers' rights. First of all, privacy, then particularly important and often overlooked, data protection, and then I'm going to identify some of the areas of challenge where we can expect taxpayers to challenge the rules in the years to come. And then I'm going to wind up by referring you back to the Ephah general reports that Michael's colleague Pasquale Pistone and I wrote a year and a half ago and talk about what that said on exchange of information. So that's the outline of the talk. If I begin then with a little bit of reminder of the background here, you know that there have been provisions for exchange of information that actually go back to the work of the League of Nations in the 1920s, and particularly in virtually every bilateral tax treaty based upon Article 26 of the OECD model, and going back to the first draft in 1963, we have had provisions for exchange of information. Exchange on request, where there is a specific request for particular information. Spontaneous exchange, where a tax authority receives information which it thinks another authority would be interested in. And then increasingly important, automatic exchange, where large categories of information are exchanged on a regular basis between different tax authorities. Aside from bilateral treaties, we also have the multilateral instruments, the OECD Council of Europe Multilateral Convention on Administrative Assistance, originally drafted in the 1980s, but in the last couple of years, a growing number of countries have signed it. And when I checked the other day, there were now 106 signatories to the Multilateral Convention, most of them having signed in the last 5 or 6 years. In the last few years, we have moved very fast from exchange of information on request to automatic exchange of large amounts of information. And we have several, sadly, non-identical systems for exchange. We have exchange bilaterally. We have tax information exchange agreements. We have FATCA with the US. We have some country-specific FATCA arrangements. We have the EU Mutual Assistance Directive. And now we have from the OECD the Common Reporting Standard. All of that, I think, is very well known. But the area that I want to focus in on is safeguards for taxpayers' rights. Because in all that development, very little attention has been given to effective safeguards for the rights of taxpayers. So let me turn then to the first area where safeguards are important, and that's the whole question of privacy. The European Convention on Human Rights contains in Article 8 a general right to privacy. Everyone has the right to respect for his private and family life, his home, and his correspondence. As you will know, that is not an absolute right. It is a qualified right, and a government may interfere with the right of privacy, provided certain conditions are met. The interference has to be in accordance with the law. It has to be necessary in a democratic society, and it mustn't be disproportionate. And that right to privacy applies to all situations where information is gathered and exchanged. It's not just the European Convention, but also the European Charter of Fundamental Rights also contains an equivalent provision, Article 7, respect for privacy and family life. And in this area, we have already had case law from the European Court of Human Rights in Strasbourg on the right of privacy. There's an old case called X versus Belgium, or sometimes referred to as Hardy-Spurlet versus Belgium. By the way, you may wonder, how comes an anonymous case, X, we know who the litigant was? Well, the case was anonymized in Strasbourg, but if you go back and read the Belgian court cases, you discover that the name of the taxpayer is there. So it's half anonymity here. We know that Mr. Hardy-Spurlet was being investigated by the Belgian tax authorities. They asked him to produce information from his bank statements, information to show what he had spent his money on and where his money had come from. He said that disclosing that information would disclose intimate details of his personal life. I don't know what he was spending his money on, but he didn't want people to know about it. Anyway, the European Court said he has a right to privacy, and any gathering of information by a tax authority is in principle a breach of that right to privacy. But as long as it's in accordance with the law, necessary in a democratic society, and it's not disproportionate, the tax authorities can have the information, which they were entitled to there. Another case here on cross-border information, the French authorities investigated Monsieur Funke, and they asked Monsieur Funke to produce information about his overseas bank accounts. The case went to Strasbourg, and again the same approach. Right to privacy. Was there an adequate basis in law for obtaining the information? In that case, no, there wasn't, and Funke was entitled not to produce the information. So the collection and transmission of all personal information for tax purposes has to be in accordance with the law, and it has to be proportionate. A note, there are other rights that may also be engaged, as well as the right to privacy, like the right to a fair trial or non-discriminatory provisions. We've had more recently cases, both before the European Court of Human Rights and before the European Court of Justice, on the cross-border exchange of information. Ephah in Germany was a case that came to the European Court in Strasbourg on the Mutual Assistance Directive, where Germany sought information from Austria. Was that in breach of the right to privacy? No, said the court. It was in accordance with the law, and it was proportionate. More recently, cases from the Luxembourg court, the Janier case, showing how difficult it can sometimes be for a taxpayer to get the tax authorities to obtain information, and then the rather strange case of the footballer Jiří Sabou. Jiří Sabou is apparently a well-known Czech footballer, though I should say one of my sons is probably more interested in football than anything else in life. And I asked him, had he ever heard of Jiří Sabou? And he said he'd never heard of him. Well, Jiří Sabou, when he calculated his tax in the Czech Republic, he sought to deduct fees paid to agents who had assisted him in possible approaches to various football clubs. I think Arsenal, Manchester United, Chelsea, these were some of the clubs that were apparently interested in him. Well, the Czech authorities didn't believe that they were interested in him and asked, amongst others, the British authorities to check the information. And the British authorities contacted Arsenal and Chelsea and Manchester United, who said, Who is this person? Sabu challenged the exchange of information on the grounds that he had not been allowed to be present when the football clubs were interviewed or questioned in England, nor could he be involved in the gathering, in the formulation of the questions being sent. The European Court in Luxembourg said he had no entitlement to that. This was still an investigation stage, and therefore he did not have the right to a fair trial to participate in that process. So we have already cases on the area of privacy and human rights and exchange of information. So summarizing, all gathering, retention, and exchange of information is prima facie a breach of the right to privacy. But if it is in accordance with the law, necessary in a democratic society, and not disproportionate, it will be permitted. Successful challenges before the courts will be rare, but nevertheless for tax authorities, best practice is always to use exchange, both to obtain information to secure the confirmation of tax liability and also to exonerate the taxpayer. I want to move from privacy to the other area, which I think is particularly significant and which has largely been overlooked in the move towards automatic exchange, and that's the whole area of data protection. Data protection is sufficiently important that it is protected and guaranteed both by the Treaty on the Functioning of the European Union, Article 16, everyone has the right to the protection of personal data concerning them, and also in the Treaty on the European Union itself, which also in Article 39 requires provisions to be adopted for the protection of personal data. The European Charter of Fundamental Rights also specifically identifies the right to protection of personal data concerning the individual. Of course, the whole area of data protection is very modern, and we see no equivalent to this in the European Convention on Human Rights, which predates the gathering of large amounts of data and the exchange of large amounts of data. For the ECHR, we have to rely only upon privacy. The provisions in TOFU and in the Treaty on European Union have been brought into law in Europe, firstly by the Directive 95/46 on data protection, and then earlier this year, as you will know, after a long period, a regulation on data protection has been adopted, the General Data Protection Regulation, GDPR, Regulation 2016-679. That will go into effect as from May 2018. And like all regulations, it will be directly applicable and will become law in all EU member states. Interesting question whether it will ever become law in my country, but anyway, we shall see there. What does the data protection regulation say? Article 1, the regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data and rules relating to the free movement of personal data. It protects fundamental rights and the freedoms of natural persons, and in particular their right to the protection of personal data. Can I just, by the way, mention a small side point here? The protection of data is, of course, focused on personal data and the data of individuals. An interesting question that comes up is, what about the data of companies? Company data is not specifically protected. My own view on that is that if you don't protect the data of companies, particularly small and medium-sized enterprises, very often you are not protecting the data of the stakeholders, the directors, the shareholders, the participants in the company. To my mind, it's a very small step to move from protection of individual data to encompass corporate data protection as well. But let's focus for the moment on individuals. They're clearly covered by the GDPR. And if you look again at further provisions, Articles 13 and 14, a data subject, that is any person whose personal information is being gathered and processed, the data subject has a right to know that there is the collection of data about them from a third party. Only very late in the process of adopting the Common Reporting Standard and the Directive on Administrative Cooperation, only very late was it remembered that every time a financial institution gathers data about a non-resident account to supply that to their tax authority, every time they do that, they have to notify the data subjects. So the account holder has the right to be informed of the gathering of the information about them. And Article 15 of the GDPR, the data subject has the right to access the data and the right to rectify it. I don't know how many of you in the audience work for banks that are busily implementing the Common Reporting Standard. But one of the things you probably know you have to do is to notify every non-resident customer that information about them is going to be exchanged, and then they have a right to seek that data, to examine it, and if it's inaccurate, to rectify it. Those rights can be modified, but it's unlikely that they will be modified merely for tax purposes. And just as a little warning for those who handle data, Article 82 of the General Directive states that there is a right to compensation for every data subject whose data is unlawfully processed. There are specific provisions in the General Data Regulation on the transfer of data to third countries. The primary provision is Article 45, which says a transfer of personal data to a third country, anywhere outside the EU, or an international organization like the OECD, may take place where the European Commission has decided that the third country, territory or specific sectors within that third country or the international organization ensures an adequate level of protection. So if there is an inadequate level of data protection in another country, the Commission cannot clear exchange to that country. There are provisions for exchange before there has been a view from the Commission, but if the Commission comes to the conclusion that a country has inadequate data protection, then they cannot exchange data, authorize exchange with that country. The whole area of data protection has been one where there have been warnings out there for several years. Under the old 95 directive, there was a committee called the Article 29 Data Protection Working Party. And several times over the last years, they have issued warning letters, warning that FATCA CRS does not adequately respect data protection rights. There's a letter there from the 21st of June 2012 about FATCA. You can read later, if you like, a letter of 2014 about CRS. And then more recently, some specific recommendations about the guarantees that are needed to ensure that exchange of information meets data protection requirements. I am still not certain that in the design of the Common Reporting Standard and the directive on administrative cooperation, these warnings have been sufficiently heeded, sufficiently looked into. And as a consequence, we come to the rather limited change that was made to the 95 directive on administrative cooperation. The original directive said very little about data protection. But just under 2 years ago, it was amended to remind everyone, firstly, at the bottom of that screen there, that all reporting financial institutions are data controllers for the purposes of the directive, meaning every bank, every stockbroker, every trust company reporting information is a data controller. And then added to that, and I'm sorry that the text is rather long, and in English and in German, but if you read it quickly, you will see that there is a reminder there that every financial institution has to inform the data subject of exchange of information in time for the data subject to exercise their data protection rights. And also very important there, subsection 4, information processed, and that includes information exchanged with another country, shall be retained for no longer than necessary to achieve the purposes of the directive. So where a country receives information by exchange, they must destroy it after they have used it for whatever purpose it has been provided. So bringing this together under data protection, how is this going to work in practice? What purposes have been identified for the exchange of information? Have the purposes been identified specifically clearly enough? Can information be used, for example, to profile taxpayers? How long can data be retained before it has to be destroyed? What about information being sent to a third country which has inadequate data protection? Already we have decisions that some countries, there's an example there in respect of the Canadian province of Quebec. Quebec has apparently inadequate data protection. If Quebec has inadequate data protection, what about other countries, third world countries, for example? Do they have adequate data protection? What will happen if a country is denied access to data because it has inadequate protection? That leads us to the third area, or the final area under exchange of information, before I mention the Ephah report. One thing I think we can be absolutely certain of is that there will be legal challenges to the exchange of information. There already have been some in other areas. Can I remind you of one of the cases before the European Court, the digital rights case from Ireland, which concerned the retention of information relating to telephone calls. And that was retained under a European directive. And the European Court in Luxembourg struck down the entire directive on the grounds that telephone information was being retained for too long a period of time beyond the purpose for which it was needed. We've had other challenges as well. That case is not exactly on exchange of information, but it's a rather interesting case to watch because we're going to have a grand chamber judgment in the next couple of weeks on this. I can't even begin to know how to pronounce the name of the case. Satakunnan Markkina something or other. It's a case from Finland. And Finland is one of those countries where you can find out how much your neighbors pay in tax because it's in a public register. And this company has been publishing for a number of years a newspaper where you could buy the newspaper and you could find out all the amount of tax that your neighbors were paying. Well, the Finnish data protection authorities ordered the company to stop publishing. And the company has taken the case. It's actually gone to the European Court, and now it's gone to the Court of Human Rights, because they argue that they were simply journalists, just providing journalistic information about tax payments, and they're arguing that their rights as journalists have been infringed by the action of the data protection organizations. There's a judgment expected very soon on that. But more specifically to the area of information exchange, we've had the WebMind licensing case where information was obtained by a tax authority through covert surveillance. That was held to be consistent with the law. BARA is a Romanian case concerning exchange of information, but actually within Romania, between two different government authorities. And the Court of Justice said, as we've seen a couple of minutes ago, where information is being exchanged, there is a duty to notify the data subject of the transfer of data. The case to watch is the last case on the list, Berlioz Investment Fund. It's a case where a Luxembourg investment fund has been asked to supply a great deal of financial information to the Luxembourg authorities in order that they can send it to another country. And the Luxembourg court has asked a series of questions about the compatibility of that request with privacy, with data protection, with other rights under European law. There's to be a hearing in that case just in a few days' time. And I guess after that we will have the Advocate General's opinion. I think it's Advocate Wathelet again. And then we'll have a judgment next year. Very much a case to watch on the area of challenges to data protection. That leaves me, I think, just 38 seconds to remind you very briefly of the Ephah General Report from a year and a half ago. Those of you who are members of Ephah, and I hope in an audience like this, you are all members of Ephah. You will recall that for Basel a year ago, Pascal Pistoni and I prepared a report on the practical protection of taxpayers' rights. We identified 12 areas, one of them being cross-border exchange of information. And our methodology was to look at branch reports, and from that to develop a series of minimum standards and best practices, which we hope tax authorities would follow. And in the area of exchange of information, we identified a number of minimum standards. So, for example, the requesting state should notify the taxpayer of requests for information unless it would otherwise interfere with the exchange. If information is sought from third parties, it should always require judicial authorization. Information should not be received unless the receiving state observes high standards of data protection. And then we also identified some best practices. For example, second one there, where there is a cross-border request for information, the requested state should also be asked, not just for information that confirms that the taxpayer is liable to tax, but also for any information that might assist the taxpayer in showing the taxpayer is not liable. A completely balanced approach. Well, I hope, ladies and gentlemen, you will have a chance at some time to look again at those minimum standards and best practices. When we asked countries about their observance of those standards, the answers were a little bit disappointing. For example, does the taxpayer have a right to be informed before information is exchanged about him? The figures in brackets, only 7 countries said yes. 34 said no, and no countries couldn't answer the question. Does the taxpayer have a right to be informed information from third parties? Again, only 9 said yes. As many of you will know, we've established an observatory to monitor the observance of these minimum standards, and we hope very much to show an improvement in the protection of taxpayers' rights in this area in years to come. And with that expression of hope for the future, I will leave you. Thank you very much indeed for listening to me this morning. Thank you.
Thank you so much for this wonderful lecture. It was quite impressive. And I think it's time for the first open discussion. Ladies and gentlemen, bitte beteiligen Sie sich ganz lebhaft an der Diskussion.
Please participate in this discussion. I would ask you to raise your hand if you want to say something. Professor Schön was the first one to ask a question. Ich soll die Debatte anfangen. Das ist sehr schwierig für mich.
So my main task would be to congratulate both of them for laying the ground for the upcoming debate, and I think it relates very much what both of them have said to the overall topic of the conference series, etc. So my only questions refer to where do we go from here? Und vielleicht darf ich mit Michael Lang anfangen. Ich teile
I totally agree with you, Mr. Lang, that an arbitration procedure would be a great step in the right direction, or the agreement of arbitration procedures also if they have a preventive effect. But that the arbitration procedures with the baseball arbitration won't give us what the legal aspects need, which is a corpus of decisions, of interpretation, a practice that becomes established on which others can build. So my question would be whether the case of Germany and Austria, which has been presented to the European Court of Justice, could encourage us to use the European Court of Justice as an arbitration court within Europe that may be on the line of the draft of a directive. And in any case, for the first time, it would be a supranational court which would be authorized to interpret double taxation agreements and take autonomous decisions independent of countries. I think this would give it authority beyond Europe, because basically there is no competitive Court of Justice in other parts of the world. So my question to you is, in the course of the reforms that you mentioned, should one say that German-Austrian double taxation agreement might be a model for the future?
Very little to add, but I would like to ask him about this change of paradigm from individual information exchange on request to the tsunami of automatic exchange of information which will come up in the future. And you have referred to a large extent to the legal limits, data protection, etc. My question is about the technical limits. We have seen WikiLeaks in Luxembourg. We have seen Panama Papers. We have seen many other inroads by illegal hackers to data storage in banks, but also, of course, in public authorities. So to what extent has the individual taxpayer some sort of instrument, some tool or right in his hand to force tax authorities to set up sensible and robust technical data protection? Because what we'll currently see is that you get a lot of legal instruments in your hand. You get guarantees and warranties from tax authorities, and then some third party within a minute accesses it all and makes it visible in major newspapers around the world. So is there any instrument to secure technical data protection in the future?
Gentlemen.
Ja, dann beginne ich vielleicht.
So let me start to answer the first question. I can underline every sentence that you expressed in your question. I also think that if we are moving towards international courts, if you think about that, legal protection has to be positioned there, and then the pragmatic approach would be to focus on existing courts. Of course, you could have visions about an international tax court of justice, but that would be very unrealistic. It's far more realistic to focus on existing courts. And when these double taxation agreement, Germany, Austria, happened, I actually participated in it. We had a certain situation at the time at the university in Vienna, which prepared the basis for this regulation. And a colleague of mine dealt with that. We had a research project as well, and I was very happy that the two negotiating partners for this agreement took up our thought. The case that is before the European Court of Justice at the moment is a little bit atypical, not a very fortunate case. It's not a case of an interpretation of the model agreement, but a specific regulation between Germany and Austria. Exactly what the two of us are hoping for in the long term, i.e. that there's a further legal acceptance, a training, a development, so that one could arrive at a supranational court which is independent of individual nation states. And I don't think we will see that in this case, but in future cases maybe we will see that. And I think, and I'm saying that in the presence of Phillip Baker, because I know that we are of different opinion here. The idea that here we have a generalistic court which would decide shouldn't bother us. Of course, not every one of us are entitled to criticize the adjudication of the European Court, but we're also authorized to criticize the adjudications of a German court. That is part of a culture where you have law and order, that not everybody agrees with every decision. So that could happen with the European Court of Justice as well. And I think that courts that consist of generalists aren't so bad, because if I think about the adjudication of certain disputes, if one had somebody who just had tunnel vision at the time, then I think probably one would never had any adjudication regarding basic liberties and rights, which was provided by the generalists who really questioned what things that we as tax experts consider to be a matter of course. And for example, the limited or unlimited obligation of paying taxes, and that was good that these were generalists. So I think it's good if there are courts who don't only exist of specialists but also exist of generalists, and I think that should apply to the European Court of Justice. Well, I know that Phillip Baker would prefer a tax court or fiscal court consisting of specialists.
I have to take this off because otherwise you'll hear the English translation or the German translation through it's actually there. Yes, I'll respond to that point. If you think about issues that arise through mutual agreement procedure, they are often extremely technical issues of international tax, very often complicated issues to do with transfer pricing, where there may be examination of a large amount of documentation, examination of expert evidence. I have a huge admiration for the European Court of Justice. I have to say that because I'm waiting for a judgment in a case at the moment there. But I don't think they have either the time or the expertise to deal with these very, very highly technical cases. And the danger is that if they try to deal with them, they will show their lack of experience and expertise, and that damages the reputation of the court. I personally think that we need a European tax court separate from the Court of Justice, and I think we've needed that for years. I spoke at a conference in Berlin about 15 years ago, and I said we ought to have a European tax court. And I remember somebody from the Commission saying, oh no, not another change of the treaties. That the reality is, and sorry to come back to Brexit, there as a potential outsider, institutions that were set up 60 years ago need to be reviewed. And one of the institutions, I think, is the Court of Justice. And one element of it is creating specialized courts. And I would say a specialized tax court established within the European Union would be the sort of body that would be able to answer these questions, but not the existing court. One other little point, if I may, actually, on the arbitration question, that's the question of baseball arbitration. I don't know why we have to go to America. Baseball. I mean, surely we can have football or cricket arbitration instead. I'm actually on a panel of arbitrators under a cross-border arrangement that provides for baseball arbitration. I haven't yet actually had to decide a case, but I was asked a couple of years back to be prepared to decide a case, and we started to get ready, and then the case was settled. And I realized that as a chairman of the arbitration body, in principle, I could have just said, yep, I could just choose either of the two answers, but I realized that I would actually have to justify it to myself and to my co-arbitrators, and in principle be ready to justify the answer to the world outside. So I'm not certain that baseball arbitration doesn't require you to put down your reasons and explain them. And if you put them down, as I think any arbitrator is likely to do so, there's, I think, no reason why suitably removed or identifying details, they could not be published. But can I turn to Wolfgang's question? I have to say to Wolfgang, actually, I think that's the first time I've heard you speak German. You speak it very well, I have to say. Every conference I've been at, you've always been speaking perfectly English. You asked about the practical side of exchange of information, and I think we all know what's going to happen. Information is going to be leaked in a massive scale. I can remember a couple of years back working, in fact, with a German law firm here. You may remember that there was a leak of information from Luxembourg, and the information was sold to the German Secret Service, who then provided it to, amongst others, the British. And the Indian government asked the British and the Germans for information about Indian citizens who had accounts with that Liechtenstein Trust Company. It was Liechtenstein Trust Company there. We warned the British, we warned the German authorities, if you give this information to India, it will be in the public domain within days. And they ignored us. And I happened to be in India at the time the information was received there. And literally within 2 weeks, the details of the individuals who had the trust accounts were in the public domain. Not all the individuals. The individuals who were businessmen, their details got public. The individuals who were politicians, their details still were kept private. We know what's going to happen, and quite frankly, the OECD is, I think, acting in a cavalier fashion. I sat on an Ephah panel next door to the nice lady from the OECD who was responsible for this, and she said, we all know leaks are going to happen. Well, if you know leaks are going to happen, you can't go down this route, because in the case of some countries, when the information is leaked, people will be kidnapped, their children will be kidnapped, they will be held for ransom. And quite frankly, I do not think that there are adequate safeguards in place, nothing like adequate safeguards in place yet, to guarantee the protection of exchange of information.
So baseball arbitration, cricket arbitration. Our first finding of this conference might be the tax law will become much more sportive in the near future. Weitere Fragen aus dem Publikum. Another question from the audience.
I have a question to Professor Lang. In view, you said mutual agreement procedures are considered to be insufficient, arbitration procedures are more suitable, and the European Court of Justice has a special regulation for Germany and Austria. And as a practical person, I would be interested. We've got a relatively well-respected decision by a German court, and the decision was at the end of the last year relating to treaty overridings. And let me just put it very casually. The statement is that the special regulations or the most recent ones supersede the older ones and the more general ones, and one could say Germany's first. And the following questions arise. First step, if I call the EU Court of Justice relating double taxation between Germany and Austria, what would the European Court of Justice decide? Would it decide about the double taxation agreement, or would it decide as a supranational institution, would it decide on a generally binding question? I think this is significant because we heard that international law, in case of that, would be secondary in terms of a treaty override. So as a practical person, what does that mean for me in practical terms, this decision of the European Court of Justice? And the next question is, how could that be implemented, if necessary, at home in our country? And that, from a scientific point of view, I would be interested, even if I'm diverting from the topic. How do you see the situation that the question of a fair price, which we often deal with in a mutual agreement procedure, is becoming more and more precisely defined? And wouldn't that limit the leeway to come to an agreement between the two parties? So these are two very different questions. The procedure in front of the European Court of Justice is meant to be a procedure where two parties can come to an agreement, and that gives member states the opportunity to, where disputes which are in any way connected to the law of the European Union, but which are not directly law of the European Union, and that is what this regulation is based on, and then the legal claim of the taxpayer is based on basically it's a procedure between the two countries where we're talking about the interpretation of the international agreement that was concluded between Germany and Austria. So it's not about the interpretation of the law of the European Union. And the question is always general. If you have a court that has supranational members, and if the countries don't stick to the decisions of this court, then basically the rule of law is limited also under international law. Some people will have followed the discussion as far as constitutional law is concerned. And the European Court of Justice, many years ago, gave a ruling on signs in the country in a foreign language, and the country just didn't stick to the ruling of the European Court of Justice as far as this use of foreign language is concerned. So the European Court of Justice, where the law of the European Union has developed a very effective adjudication, where it has actually agreed with the law of the European Union. And I think there aren't enough experiences as to whether with adjudication can be continued in the future, and where we can say this is the law of the European Union, or here the European Court of Justice acts as a supranational court. And if a country doesn't stick to that or comply with a ruling, nothing basically happens, as is often the case under international law. So my hope is that between these two countries, and especially the case that is pending at the European Court of Justice, and here we're not talking about treaty override, that would be then implemented, the court's ruling. The other question that you're also relating to transfer prices, if I understood you correctly, there is a restriction of implementation scope. That's quite interesting. You said that the restriction of the national regulations give the administration authorities less leeway for mutual agreement procedures. This is one aspect of the question, and the other question is whether such national regulations would have to be examined as to whether they meet Article 9 or 7 and comply with these articles, because that is then a question that ultimately would have to be clarified in an arbitration procedure, or if it were Austria or Germany, it would have to be clarified by the European Court of Justice if ultimately Article 9 is very wide-ranging. But in terms of the idea, in the case of Germany and Austria, for example, the court would have to decide whether the individual states have leeways which basically exist, and whether an arbitration court can curtail these leeways and this scope. So from this point of view, I think these regulations would always have to be looked at critically to see whether they really cover the entire span of Article 9. Ladies and gentlemen, unfortunately, time over for the first session. We've exceeded our time anyway. You're well, and the coffee break is waiting for you. I would like to thank the two speakers very much indeed, and thank you for the open discussion.